Hi, my name is Gabriella Agostinelli and I'm an attorney with Berard Immigration Law. Today I want to discuss something called direct consular filing. Now typically when somebody is applying for a green card based on a familial relationship and are outside the United States for doing so, it's a three-step process. You file something called a Form I-130 Petition for Alien Relative with United States Citizenship and Immigration Service. Once that application has been approved, the application is transferred to the National Visa Center, which is essentially the intake center for embassies and consulates worldwide, which are getting ready to process final interviews for green card applicants. Once the NVC has all the documentation that they need, they will then flip the case over to the actual Department of State, consular, or embassy location that will conduct the actual interview. The applicant will attend the interview, and at that time, they will adjudicate the case. The individual will enter the United States as a green card holder, and all is well. But right now, with the first step of the process, that filing of the Form I-130 taking over a year at times to approve, what happens in situations when a family is already living abroad, one of which is a U.S. citizen, and for whatever reason, be it a medical emergency or a job relocation that you've just heard about very quickly, what are you going to do? With over a year waiting time, that's not quite feasible for transferring a family over to the United States, because in many cases, families will be separated, or maybe somebody will miss the window to take that job opportunity because the government won't be able to process the application for all family members to move to the United States in time. Well, not to worry. In situations where USCIS does not already have an international office, there may be an opportunity for family members to quickly get an approval of that first step, the Form I-130 petition, by directly filing that petition at the embassy or consulate location. This is called direct consular filing. Instead of submitting the I-130 petition with USCIS, here we're going to have the applicant and the sponsor put forth a variety of materials to the consulate or the embassy and asking, is there any way you can adjudicate this for me quickly so that my family and I can get to the United States quickly? Well, in that application, we have to ask and put forth the reasons why that person is entitled to be moving to the United States so quickly. And if that argument is taken into consideration and the government is serious about taking this case on, we're finding that generally these applications are getting approved in about 1 to 2 months from the time of initial contact with the embassy. And by the way, the only way they could actually get that approval from the embassy is if USCIS assents to doing so from the Department of State first. But all is well that ends well. Our clients are quite happy with this option. They're able to enter the United States much more quickly than they would the traditional method. Of course, you still have to go through the National Visa Center and attend the final interview at the consulate. But all in all, this application process shaves probably about a year off the process, which is a tremendous benefit to our clients. And we'd be happy to assist you if you do have a matter pertaining to an emergency that you need to go to the United States, or for whatever reason you need to be in the United States quicker with your foreign spouse. We'd be happy to assist. Give us a call today.